Okay, we're going to call the meeting back to order. She's going to wrap up real quick.
Oh, should I?
Yeah, because we need,
however.
we're going to probably have discussion. Do you want to let her try and ask for a continuance? Can we close your hearing for
Sure.
2 seconds and let
Oh,
her?
yeah,
Because they have
absolutely.
graduations to attend. I'm not trying to be rude to everybody here.
No
if
problem.
that's okay?
Yeah.
You sure?
Of course, yes.
Okay. So
Madam Chairwoman, Commissioners, my name is Charnel James.
I need to
represent
open the hearing for which one
sorry.
you're going to discuss first, because we're going to have to
Number
discuss them
8.
individually.
Number
Okay.
8.
Okay? We're going to open the hearing for item number 8.
Commissioners, my name is Charnel James. I represent the appellants in this case. They had a son that was in graduation and had to leave for the hearing, so we are asking for a 4-week continuance in order to accommodate my schedule. On the 21st of June, I have to be in Cathedral City, and there's no way for me to make it back from Cathedral City in time to attend a planning commission on the 22nd.
Okay, I would like to ask, just get some clarity over here. She is representing the same appellant on 3 different cases, 8, 9, and 10 on the agenda. Can we approve all of these at once or deny all 3 at once, or do we need to open and close each one individually?
I think if you make the record clear that you're opening all 3 for this limited purpose, that
Are you okay with that?
I am okay with that.
Okay, so I would like to open the hearings for 8, 9, and 10 for discussion and a request for a continuance to July 13th is the date you gave?
Yes, ma'am.
Okay. Do the commissioners have any comment on that?
I'm good with it.
Everybody good?
I would just like to know if the planning director has any objection to this.
Annette,
I
is
have
the
no
schedule
objection.
okay for July 13th to add?
I believe so, yes.
Okay.
So we're at that point, with the addition of these 3, we won't have 10 or,
We'll try not to stack it like we did today.
okay?
Okay. I have to take public comment on this. So does anybody have any public comment? I'm starting to like all of you. Okay, so on that note, can I get a motion to continue items 8, 9, and 10 on the agenda to July 13th?
So moved.
Second.
All right, all in favor?
Thank you, Madam Chairman. Can
Thank
I
you.
have you open item number 12, please, Your Honor?
Okay, so we'll open item number 12 on the agenda for Luigi Di Manicas. I don't know if I'm saying that
Di
right.
Domenicus.
Okay, thank you.
The Charnel James appearing for the applicant, Luigi Di Domenicus. I'm requesting a continuance of 4 weeks for this hearing in order to accommodate my schedule. I have to attend Cathedral City County Planning Commission on the 21st and cannot make it back in time for a 22nd hearing date here in Calaveras County.
Okay, and is your appellant okay with that?
He is okay with that.
I'm okay if you pick another day.
It would have to be after July 22nd, so that'd put us in the first week of August.
Wow, that's a long ways out.
That's a long ways out. Are you sure you're willing to wait that long?
I mean, I already have a vacation planned, a family thing. So I leave on a red-eye flight from Southern California on the 14th, and I don't come back until the 22nd to Southern California.
When's the next hearing?
July 27th would be the
We
next
could do
available
July
hearing.
27th then.
Well, I think by the
We'd be
request
willing to
for,
waive the
the
45
45 day, yeah.
We will waive the 45 day on the record.
And we're doing a date certain. No, don't apologize. We're good. Okay, so July 27th. Okay, can I take public comment on that, please? See? Good people. The commissioners, can I get a motion second?
I so move.
Second?
Okay, all in favor, say aye.
Aye.
Aye, opposed? Okay, motion carries.
you.
Thank you.
Yes.
Have a happy graduation there. All right, Sarah, you are wonderful for waiting. Thank you. I appreciate that. Okay, we're going to reopen the hearing for agenda item number 7 with Sarah Hodson, and she's going to continue her rebuttal to public comment and the planning department.
Okay, thank you. I spent some time,
You needed that break.
yeah.
Okay, I'm just going to read. What? Okay. A failure to obtain a grading permit has not been a reason for denial in numerous other cases. There are literally dozens, if not hundreds, of other farms that have graded without a permit. I have done everything to obtain an as-built permit and to do all necessary remediation of my property. The permit is in Public Works awaiting approval. The full remediation with additional erosion control work, to the fullest extent that remediation could be done, is in progress currently and has already been partially completed. The county staff said that their estimate of what would be an allowable proportional adjustment is highly subjective and based on their interpretation of topographical maps. I have had an independent contractor verify the proportional adjustment allowable on my site, and it added up to 13,390 square feet. The objective analysis indicates the allowable proportional adjustment on my site is 10,890 square feet larger than the subjective analysis conducted by the county staff. There's clear photographic evidence showing plants in the 4,000 square foot lower area on May 26th. This was taken by code compliance. This is not my photo. The reason this wasn't in my site plan was because I knew it couldn't be included for purposes of cultivation. It was all completely outside the setback line, and it was graded before I ever owned the land. It wasn't something I graded and felt needed to be represented in my diagram. I understand my grading needs to be fixed, and it is in progress. However, I honestly believe that my grading falls within both the ag exemption and the proportional adjustment exemptions under the county code. These exemptions must, much like the issue of hoop houses, are not a cut and dry area of the urgency ordinance. Unlike hoop houses, there is no such secondary documentation clarifying the administration of exception cases such as my own. I have done everything I can to come into compliance. I have fixed all the code violations. Courtney Meinert has said that he's closed all outstanding code compliance issues. I hired Eldorado Septic to clean up and remediate any environmental health concerns. The septic, the outhouse wasn't just, it was in the short period of time that I had within the 10-day window, with the 3 days that were not pouring rain in one of the heaviest storms of the winter, I boarded up the outhouse. It was already discontinued in use. A little later, I hired Eldorado Septic, the company who I previously had a rented outhouse, a rented porta potty on the property from, come out and pump the pit. And I also went into Public Works to get full clarification on how to completely and 100% remediate that issue. And it has been done, and the proof has been sent to the county. I have completed and fixed my fence. It's up and running, and I implemented erosion control. I contracted with competent engineers to address the problems of my grading. I also had multiple site visits from an erosion control company, as well as the engineer. When the engineer came out and did a site visit, we spent about an hour walking around my site, and he personally said that the erosion issues, although needing fixing, were not leaving my land from what he could tell. He told me that. And the erosion control company gave me an indication of what could be done, but told me nothing more can be done until after the regrading is approved and completed. So all of it is in progress. Okay, the fencing deadline was missed. If the fencing deadline was missed, I should not have been granted time for coming into compliance. However, county staff directed me to continue building a fence in January 23rd of 2017. Even though today they are claiming that I had already missed the June 2016 deadline and should have my appeal denied on this basis. This is not a standard that has been applied to other applicants, and it is another instance of a moving target for compliance. I have been given vague direction from county staff the email I received from Tom Watts said the planning department was not insisting that my violations required immediate remediation. It was at this time I was encouraged by county staff to contract with Cal State Engineering in order to come into compliance with the urgency ordinance. This county doesn't have any written documentation addressing the ag exemption or the proportional adjustment in a way that addresses this particular issue. The Stapleton case is analogous because he was given unclear direction from county staff. I have been given unclear direction and deadlines from county staff. I was encouraged to undertake remediation as a condition of coming into compliance, and that is what I was told by county staff, specifically Tom Watts. There is a lack of clear guidance regarding the issue of grading exemptions. Again, the issue of the lack of clear communication and a definitive deadline, as well as the lack of a final inspection before I was abruptly denied, puts me in a similar situation as Greg Stapleton. How could I demonstrate compliance within the deadline required if that deadline was not clearly communicated? And furthermore, how could the county make its determination without having conducted a final inspection? Okay, I just want to thank you guys for your time and consideration and listening to this start. I know it took a long time and it's complicated, and I appreciate all your time, and I hope that you can take all the factors into consideration. Thank you.
Thank you. Okay, I'm going to close the public comment period, public presentations, and bring it back to the commissioners for discussion. Who'd like to start? All right,
I
let's not start with you today. Let's start with Karen.
I don't have any questions. I agree with the planning department. I'm going to leave it at that. I'm not going to open a can of worms. So.
The grading part of it is the part that bothers me the most, in that the applicant claims that she didn't need permits, or everything was done by May 10th, or maybe it wasn't, and the numbers kept changing. The proportional thing is a disaster. Getting the engineers to come in with these numbers, 8 o'clock this morning or some crazy thing. What little I could see on the photos we had, the engineers' numbers are just plain wrong. The 4,000 square feet off the bottom by the mine, that's not on your sketch. And I don't even know if it's in that 75-foot setback at all. The code's pretty clear about requiring a grading permit. You didn't have one. The fence is a little bit odd because of the letter saying you don't have to do it right now, but still it was months later that the denial letter went out, so I'm going to uphold the denial.
In my opinion, this is a great case of an example where if there was a master reset button that could be pushed and second chances could be granted without prejudicing all the people that have been denied in the past, this would be a great case for a reset button. But the ordinance doesn't give us that option. I am very uncomfortable denying on the basis of the lack of fencing and also on the previous violations found by code compliance. I think those violations were quite serious. I think it calls into question just how environmentally conscientious the people were that were running that site at that time. But there are certainly, I think there should be some sort of presumption that if you do solve the problems that are called to your attention, that there might be some room for redemption. I think it is unfair to have these problems resolved and then look back and say, yeah, but you were in violation 6 months ago. I have a little harder time with the fencing on this score, and that a harder time excusing the lack of fencing. in that that only occurred after the actual denial letter had gone out. But where I really have a problem is on the grading that was done and as is for the proportional adjustment due to the 75-foot setback. There was, I can see no unclear directions by the planning department, by the county. The applicant was well aware of the statute. She was reading the statute to us, and that statute clearly provides that a registrant seeking to conduct grading for this purpose beyond May 10th, 2016 must providing the planning department with a copy of a current grading permit for this proportional adjustment at the time of submitting his or her application for registration. I do think that there's probably room for some leeway in that as far as exactly when that permit needs to be presented. But admittedly, no such permit existed. I'm not convinced that there is a history of that lack of permit for the proportional adjustment being forgiven. I understand that an awful lot of expense is going into now for remediation of the grading that did occur. That grading that did occur has obviously resulted in some pretty major environmental occurrences. So I'm ready to deny the appeal based on the lack of the grading permit for the proportional representation. I tend to go with the engineer's estimate of the acreage that was being adjusted for, but the adjustment itself was unpermitted grading, and that was contrary to the ordinance, and so I'm ready to deny the appeal.
Okay. I have several issues to address. One is going to be that I kind of half agree with Tim for the first time ever, so this is history. It's all right. The fencing issue, I have ruled in the past, June 30th was the deadline. If you are a grower and you're a business person, you don't need code compliance to tell you to put a fence up. It's in the ordinance, it's clear, it's black and white. But, Sarah, because you received that letter from code compliance written the way it was, I would like that removed from the resolution. I believe that it wasn't clear, and I'm not willing to rule on that being written the way it was. So I would remove the fencing as well as you stated, Tim. I want to reference, bless you. I want to reference that ag. You keep bringing up ag, and under the urgency ordinance 1795130G, I'm taking a little bit of an issue with this because, and I heard it not just from you, I heard it from public comments that, and some of them that are registered growers, speak to the fact that under agricultural, we can grade our land. Well, if you are putting in a grape vineyard, I guess you could. But under the urgency ordinance, which is what this applies to, it point blank states, notwithstanding in fact that Health and Safety Code section 113-62777 declares that medical cannabis is an agricultural product for purposes of that section, and the MRSA and Business Professions Code section, the cultivation of cannabis for medical use shall not be permitted in any zone within the county of Calaveras unless it complies with all requirements of this chapter. And it does declare, if you read H as well, it does declare that this agricultural, under this phrase in the urgency ordinance, does not allow the grading under the agricultural, and this takes precedence over the county ordinance that you guys are quoting. I want to talk about Stapletons because that's a big deal to me. I think I'm getting near the 100 mark of appeals. And that is the only appeal I have ever overturned, ever. The case was entirely different than this case for me. Code compliance did not write him up. they call, or they were on the phone with a worker and relayed that message over the phone from worker to the registrant. And he brought documentation to us that the code compliance wrote up that was incorrect. And he was able to bring documentation forward. He brought his seller's permit properly dated. He brought his hoop house permit. He brought trailer permits. All the things he got wrote up for, he didn't have, according to code compliance, but all along, the permits that he had predated code compliance's letter. Completely different case. It did not even compare to yours in any way, shape, or form. So on the issues of the denial, there's a couple of things. Sarah, you worked super hard. I seen the pictures. I seen what you had to clean up. I seen what you had to change. I think that you did clear up your violations. We had code compliance here today say that you cleared all those issues. So I personally, I feel like Tim. I want to, if you guys would consider remove ruling on the code compliance, because she did fix all those issues and she remediated them within 10 days, which I think was great progress. I want to remove the issue of the fencing only because of the letter from code compliance. I don't want to rule on that. I think that threw a curveball at me. If that letter wasn't written that way, I would have ruled on that June 30th date. I've ruled that before, but on the grading issue, I just can't get over that one. We're talking about, according to your engineer, whom I would level all my confidence in the engineering company. There's 30,000 square feet that has been leveled and terraced, and I can see the runoff. I can see the mudsliding that happened because of it. I know you tried everything to remediate. I know you put hay bales. I know you did wattles. And even with that being done, it's still an environmental issue. So under the agricultural and under the way that the urgency ordinance is written, I believe permits should have been had. I don't think it should have been terraced that way to begin with, but that's beside the point now. You're fixing the problem. I thank you for that, because that's the biggest concern we have in this county. Who's going to get up and leave us an environmental mess? Not you, because you're handling it. So that's my recommendation. And now we get to hear from Commissioner Wooster, because I put him on the hot seat back there.
Okay. To me, there was a pretty clear violation of the urgency ordinance with respect to the grading after May 10th. There wasn't any permit that was required. The way this is supposed to work under the urgency ordinance is if you want to conduct grading for a proportional adjustment, you're supposed to go to the planning department and give them a grading permit for exactly that. And if you had done that, then all of these issues wouldn't be here. And we would know what proportional adjustment you would have been entitled to and where you were going to put it. None of that happened, and that's a problem. On the fencing issue, it's pretty clear to me that there was a violation there too for the growing year 2016. And we have all of these code compliance problems that existed starting in 2015. Having said that, and if nothing else had happened, I would vote to deny this appeal. But more happened. First of all, on the grading. You were given an opportunity and directed by various county people to come up with as-built grading permit and do remediation, and you did that. There is a kind of an interplay between code compliance and compliance with the ordinance. It's not entirely clear to me how the two work together, but what it does appear to me is that if I'm an applicant out there and I'm dealing with public works, or if I'm dealing with code compliance, or if I'm dealing with the planning department, to the person on the street, it's the county. And when public works says, go get yourself a grading permit, and you're in the process of trying to comply with the ordinance, that's the county, to my way of viewing. There is a huge issue about the amount of proportional adjustment. I think it was the burden was on you, the applicant, to prove what that was and how it got there, and I don't think that's actually been done here. And so as far as I would go on proportional adjustment, which may be a moot point, given what I've heard so far, would be, I would say that you can grow on the upper northeast terrace where you grew before. You can grow on the lower terrace that you were growing on before. You can grow on whatever portion you graded up to May 10th that's not within the 75-foot setback area. And you could grow on 2,500 feet of proportional adjustment, which the planning department seems to think would be appropriate. If I were making this decision, I would try to put, or I would put, as a condition of registration that you get the remedial grading and erosion control done. And if it's not done, the registration gets canceled. On the fencing, I don't have a lot to say because there seems to be some view, same as mine, that there was a violation as of June 30th when it wasn't up. But given the advices you were given and the open-ended time in which to correct that, I would not include that as a basis for denial. And that's particularly true because the fencing has to be of a cultivation area. A cultivation area is not the same as a cultivation site. A cultivation area only exists when you have live medical cannabis plants there. And therefore, for the period during the winter months, when there were no live medical cannabis plants, there is no fence required, in my reading of the ordinance. And you have made it clear that you have not cultivated this year, and you have the fence in place, obviously before any plants got there. With respect to code compliance, the way the ordinance reads is you can't get a registration until you fix the code compliance problems. You did. All of them prior to the denial, with the exception of the fencing, which is a different subject. And so my view is that, to my way of thinking, fundamental fairness would require that this appeal be granted to the extent that I've stated. That's my view.
Can we have discussion?
Absolutely.
I don't understand your position as far as the permit that was required for grading for the proportional adjustment. Are you saying that since the county said you need a remedial?
I think the county also said you need to get as-built and remedial, both things.
But in your mind, that starts the record anew so that the grading without a permit initially for the proportional adjustment is subsumed in that process?
I'm trying to look at this from the standpoint of the public and the people out there who are trying to deal with the county. And as I said, to my mind, when Public Works or planning or code compliance tells somebody in writing, you need to do this to come to compliance, that ought to count. And then when they go do that,
Well,
then it seems to
I
me
see
unfair
that.
to backtrack on it.
I see that as far as the fencing and the other code violations. But my understanding is that the county says, you have messed up on this grading, and you must do remedial grading. To me, that's very different than saying, better put up that fence now. That there was a specific requirement in the ordinance that required there be a grading permit for the grading for the proportional adjustment. And to me, that's more significant than whether somebody has submitted a seller's permit by September 7th. This is an integral part of what the ordinance is about. It is watching out for the grading.
No, I understand that, and I agree with that. But I think what she was told in writing, it all got lumped together. You need to get a grading permit in the same communications that we're talking about the code violations and the fencing. And that's where the confusion comes in. Maybe I can find it.
Great. While you're doing that, one thing that I want to make clear is that I agree with the chair that we just should not rule on the fencing and the code compliance thing. We know this is a good case example. If we say we agree with so-and-so's position and we're ruling on that basis, that we can have other people coming in and saying, oh, you did this in the Hudson case. By not ruling on it, if we are still denying the appeal based on the lack of the grading permit, then we are not ruling on the fencing and the other code violations, and without making any precedent at all, if any precedent value applies.
Well, if you look at the email of January 23rd from
You know
Thomas
what?
Watts,
I would like to, do you have a copy of the code violations? Because we don't have that. How was that written up?
Copy of the code violations.
From code compliance, where he's discussing that they wrote up, all she needed to do was get a permit for the grading and remedial the situation. How is that written up? Do you have a copy of that, Sarah?
Yeah.
Yeah, I do. Can we see that, please?
It's Exhibit A of the packet, the actual list from the inspection that.
No, the one about grading specifically.
Yeah.
About grading specifically.
Correct.
I don't have January letter.
I don't see it.
I can get it up.
It would be an attachment 4 of the staff report, I believe.
I don't have it.
It said attachment 4 of the staff report. Yeah, it's there. I'd like to make a clarification too, if I may.
Please.
The basis for denial on the code violations was the determination that a history of code violations has existed. And the code violations went for more than 2 years.
But they did, I want to just correct you for 1 second with my thoughts so that you can
Yeah.
answer me. Those code violations in 2015 played no role in my mind under the urgency ordinance. They weren't given to her for the urgency ordinance. She was giving a code compliance correction notice under the urgency ordinance. That was separate in the year 2015.
No, it's.
So that's, you've got in the urgency ordinance, you're going to reach out and find that number,
Yeah,
okay?
the planning
History of code compliance issues.
Yeah, it's in 17.95165M8.
If the planning
A,
director
two.
finds that the applicant has a history of local sanctions, fines, or penalties for violations of local ordinance, or for any revocation of a local license or permit within the prior 3 years. But it's not a part of the resolution. Is that part of the resolution?
No. Not my mistake. I thought that was it.
I'm sorry, see, that's where the
Yeah.
the conflict's coming in here with what we're looking at. So when I'm looking at it, I'm not, that wasn't listed for me to go back to 2015 and use that in the resolution. But in 2016, she was giving a whole separate list of urgency ordinance code corrections.
In January 2017.
Well, and in 2017. She was never given a code of corrections list in 2016, only 17,
Okay.
right?
I don't know.
So going back to Kelly's comments, do you have, okay, so they said attachment 4. Did you get it up?
That's this.
And what did code compliance tell her?
Okay, we're in from Thomas Watts, and it's Friday, January 20th, 2017. It says, for your information, oh, wait a minute, I'm trying to see. It's to CCR. Who's CCR?
Sarah, are you CCR?
No, CCR is the general website for the planning department for correspondence regarding cannabis.
Okay, so that's not
So
the notice
it's
that
not
she
to
received
her.
for code compliance?
No.
Okay, so that is a listing of issues.
You don't have it in your
Okay,
file?
could I speak for a moment?
I hope you will.
I want a copy of her code compliance violation by code. Code compliance writes up the list.
I think Commissioner Brewster.
I think I have it.
You think you do?
Well, if you look in the file, there's an email dated January 13, 2017.
Which file? I've got 20,000
It's on the
pieces.
the page after the one you were just looking at.
It says,
You have to come up to the mic, Sarah, I'm sorry.
You're looking to find the letter that was from January 9th from planning specifically about grading, or you're looking for the one on January 13th after the initial
I
inspection?
have January 13th here.
You're looking for
Did you ever get a written notice from code compliance
about grading specifically?
of compliance issues? Were you ever given a written notice by code compliance?
Yeah, that's all I have.
So you just got an email from them, you didn't get written notice of violation?
Correct.
okay, when I said that the grading issue got mixed up with everything else, if you look at this, what it says is, following our inspection of your something, put together a list of correction sites to come into compliance with the urgency ordinance. This is the county telling her what she has to do. Grading and erosion. A grading permit is required for the graded areas at the top of the hill. And it goes on. And then you have the hoop house and the tent, the generators and so forth. Then she goes to Public Works. If you look to her Friday, January 20th, 2017 emails, with respect to what she was just told on January 13th, she went into Public Works, they gave her a copy of the grading permit and information packet. They also told me I need to hire an engineer to evaluate the erosion grading problems at the property. They said I would add this proposed new remediation work along with the as-built part of the grading permit together under the direction of the engineer. It goes on. Now, what she's being told is to come into compliance with the urgency ordinance, she has to do these things. And that's what she did. And so I think the county should not be relying upon a violation that admittedly happened in June of 2016, now, given this history of what she was told and what she did. I don't think it's fair.
I think you've made a very good point.
I do too.
But I'm wary of other people saying, well, now you've recognized estoppel, governmental estoppel.
And emails.
In emails.
Emails are terrible.
Still, but, I mean, that's better than he said this over the counter.
Well, I think this is an extreme case, quite frankly. And it's what happened here is pretty well documented. This is not a he said, she said issue.
No, I'm saying this email it's clearly what the county in the shape of the code compliance said, and I was not taking into account that it said it's made for the site to come within compliance with the urgency ordinance, which would tend to certainly imply that an earlier problem with grading permits can be remediated along with remediating the bad grading that was happening.
Okay, she had 10 days in which to comply with all these issues. What date was she able to get Cal State Engineering in there to remediate and comply with this? Everything else was done. Code Compliance gave us, or spoke today and said that in May, everything was taken care of and she had followed through with the steps. But in that 10-day period, were you able to hire Cal State Engineering and submit that to Code Compliance?
In that email, it says she did. January 20th is her email.
There's a,
Says I called Jeff at Cal State Engineering to put down a deposit to hire him. Attaches a letter showing proof of it.
by the 19th of January, she had gone to Cal State Engineering and gotten quotes
May I
and a contract.
chime in? I don't want to interrupt the process.
you're fine.
Okay. Yeah, within the 10 days, I wrote back with a 3-page letter with the before and after pictures that's in there, and emailed that to Tom Watts. On that very same day, I also emailed him the copy of the letter and that Cal State wrote, proving that I had hired them and begun that process. And they themselves said they also sent a second copy to the county.
On
And then-
what date did he tell you you were in compliance? The 20th of January?
Yes, yeah, the 20th, within the 10 days. If I understand your question correctly.
You do.
He told you that
Yeah,
you
because I
were in
seen an
compliance.
email in here that he wrote her that said.
Right.
Everything looks great.
He said everything looks good, put a little more erosion. I went out,
Then he added the fence.
and then he
Said,
added the,
But there's no timeline on doing that.
correct.
Yeah, it's the 23rd.
I mean, the trail just, it continues on. There are emails on the 28th of February about the erosion and what she had to do, and
I checked in
on April
again.
3rd, there's another one from Sarah as a follow-up about what she's doing on the remediation work. And so it's a continual process, and, you know, it would be impossible to get the as-built grading permit and get the remediation all done in 10 days. It's just not going to happen that time of year.
Well, you've succeeded, in my mind, in bringing this within the same sort of context as the fencing and the code compliance problem.
That's what happened.
I think my concern is with the precedent we might be setting. I want to make it as narrow a precedent as possible. I think it might be good to if we were to grant the appeal, to grant it only on the basis of the grading that you're talking about. So we have a very specific issue that we're looking at, and with conditions that you were proposing that I would imagine the applicant would be more than happy to agree with. I don't know that I follow all your numbers, but I'm willing to rely on.
Well, if the appeal's going to be granted, the resolution has to deal with all the issues for denial, the fencing and the code compliance.
May I suggest that if it is the commission's intent to grant the appeal, that you sort of state your intent and direct staff to come back at the next meeting with the final resolution, and we can carefully craft the findings to keep it as narrow as possible?
I'd agree with that.
It sounds like a good idea, but I'm not sure that there's a majority here.
Well, that's what I said, if it's the commission's intent.
Okay, let's do this. Does everybody have a grasp of what we just talked about? Does anybody have any further questions? Because I'd like to poll everybody on where they stand. Okay, let's start with number one. Let's start with the fence. Does everybody here agree that the fence should be removed from the resolution, or do you want to leave it in? What do you want? And just be quick. I don't want a summary. I just want you to say yes or no, take the fence out.
I'd like to take the fence out.
Thank
I'm
you.
not sure if it's appropriate.
Okay.
I'd take it out.
It depends on what the resolution does. If the resolution grants the appeal, you have to say something about the fence.
You're not allowed to summarize in or out. We can work on it. I just need to know what your feeling is so they get an idea from us.
Well, I'd have to concur with Kelly on this, that if it's for approval of, then you need to put keep something about the fence in. You're basically reversing planning staff's finding. If you're going to deny it based on the grading, then it's probably appropriate to remove the fence. So maybe the better question is, in the overall context of the action that's going to be going, are you inclined to approve or deny it? And then if it's the majority say we want to approve it, then some feedback as to the rationale. I think we have, I heard what Kelly said. We can certainly go back and listen to tape to get the details. We can come back with a crafted ordinance, but I think we would then need to look at all of the issues and state the reasons why these were not grounds for denial.
Okay.
If, however, the majority of the commission still believes that the denial should be upheld, then you could say, well, but we're only going to deny it on the grounds of the grading and not the fencing or the code compliance issues.
Well, I guess the issue that we have here with doing that is that we need to pull each item, and then we can go for the overall.
Well,
Do you agree?
no, I think, I agree that only if you were interested, only if you were interested in denying the appeal would you want to go through and then pull on each basis for denial to see what the majority is for each of the bases. But if the overall impression is granting it, then I think that would completely change the resolution.
Okay.
Yeah.
You want a chair? Trade chairs? Okay.
Why couldn't we have why can't we agree with the appeal as to the one item? And just scratch the other two? What's wrong with that?
Well, again, if the commission was going to actually grant the appeal, that would be because the commission felt there was no basis to deny at all any of these. Alternatively,
Yeah, right.
if the commission feels that only one or more bases of the ones proposed by planning are adequate bases for denial, then we would poll the commission on each of the respective findings to see what the bases are.
I think
it's back to you.
It's back to me. Let's poll if we're going to uphold the appeal or deny. So,
I'm prepared now on the arguments and evidence pointed to by Commissioner Wooster. I'm prepared to grant the appeal.
okay,
Yes, Mr. Wooster, I agree with you.
thank you. Miss Commissioner Sisk? Deny the appeal. Okay.
I would grant the appeal.
Okay, and I would grant the appeal based on what I've seen too.
So then I would propose that someone make a motion to continue this to the next meeting, directing staff to prepare a revised resolution to support action to grant the appeal.
But I want it really well documented because, as you know, especially when it comes to that fencing, I have ruled and ruled and ruled on that June 30th date. So whatever verbiage you come up with, I'm going to be looking for something that is so enormously strict that says why I decided that that was the only one reason why I would do this.
So, I mean, I don't know if the commission wants to specifically come up, pull each other, agree on some terms of the resolution that you're looking at? Or should we just analyze
I
based
think
on what
you've
we
heard basically what we said, based on the attachment number 4 and the verbiage in the code enforcement and those emails and letters. They basically were giving her time to remediate these issues. So I would like to reference those emails, dates, and letters so that it is very well documented. Do you agree?
Yes.
Okay.
Yes.
Okay.
And if it's appropriate, I think if the staff can work with Commissioner Wooster, because you might change your specific figures on where the grows.
You would need to vote to delegate the authority to Mr. Wooster to speak on behalf
On
of the
those
commission.
proportionals, I think the planning department and Cal State Engineering need to get their heads together on that because we have issues with the site plan that was submitted, which basically is the ruling factor for me. Because she didn't say I was growing down here, I can't look at that area. That site plan meant a lot to me. So her garden may be downsized proportionately based on Cal State Engineering, based on what the county was submitted with the application. I I think that I'm gonna leave that, you guys, if you wanna vote to do something different, let me know now. Otherwise, I think it needs to be left between the planning department,
I think-
Sarah, and Cal State
I think
Engineering.
that makes a whole lot of sense, and it will be subject to our scrutiny, including Mr.
Okay.
Brewster's scrutiny when it gets
That's
back.
great.
Yeah.
And, okay, so let's, we need to make a motion and a second.
I move to grant the appeal on the basis it's been stated, with the proposition that the planning department will come back with an amended resolution.
I think we're actually voting to continue this until we see that resolution. I don't know that we can,
We need to give,
Vote.
we need to give
Yeah,
vote, to give
yeah.
direction
Yes, I
to
think-
planning department to bring it back to us for final approval,
for final approval, yes.
With the intent to grant the appeal.
with the intent to grant the appeal, and that's what you just said, right? Do I have a second for that?
I have a second. I'll second.
Thank you. All in favor, say aye.
Aye.
Opposed?
And just for the record, it's, bring it back in 2 weeks.
Thank you. So Annette, that will be 4-1. Congratulations. You have 2 weeks to go.
1 week.
You can say thank you, and then we got to keep moving through because we have another hearing.
I don't really have any words left for a nice elaborate thank you, but I just want to thank you from the bottom of my heart for listening to all the evidence and
Thank you.
making a good judgment. Thank you very much.
Okay, so we're going to move on the agenda. We have item number 11, appeal by Ismael Silva. And Paul, are you doing that one?
Yes, ma'am.
I've got to find it. Okay, you guys, I'm going to have you take it outside, please. We want to go home. Okay. Before we start, because there's a lot of confusion, I want to make sure that the applicant is here. Thank you. Where can I find my... Okay, I'm ready. Okay, so Paul is going to do a 15-minute, he gets a 15-minute time period to do his presentation, and then we'll have you come up to the podium and you'll get your 15 minutes as well. Did you bring any representation, or are you representing yourself?
No, I wanted to request continuance, if that's possible.
Based on, what do you need the continuance for? Because we're getting really backlogged. Do you have
Just
reason?
to have a better representative.
He wants to do a continuance to be able to have representation. Okay,
Can you explain why you suddenly need,
I'm just unprepared. And I got the letter kind of late.
yeah,
you mean the notice of the meeting?
Yeah, the notice of,
When did, I really don't know, when did you get the notice?
I got it actually last week.
is that true?
The notice of the hearing went out last week, but the denial was sent in April, and we received its appeal on April 25th. So it's been, a month plus, knowing that there would be an appeal hearing. I don't have a problem with continuance at this point, just given the late hour and, probably the rumminess that we're all feeling at this point. But I am concerned about continuing everything. We're just going to end up in the same situation. I would be hesitant to continue it to the 13th, just because we've already continued 3 of them to that date, and we probably will have other appeals and other projects. Would 2 weeks be sufficient?
Yeah, that would be perfect.
So if we could continue it for 2 weeks to the 27th, that would be acceptable.
How much is already on the agenda for the 27th?
Pardon me?
Do we know how much is already on the agenda for the
I'm not aware.
We just moved
We'll-
3 of them.
That was to the 13th of July,
13, we're talking about.
and one to the 27th of July. So I think we'll be able to handle one additional item on the 27th.
I would want to make clear to Mr. Silva that this is the only extension, continuance, because we do have a representative of the Sheriff's Department who has changed his schedule around a lot today in order to be here, and is here at this hour to do it. And so on the 27th, is the Sheriff's Department available?
I'm gonna ask, could you just step aside from the podium for just a moment, because I'm seeing some anxiety in the public and I'd like to take public comment.
Okay.
Okay. Does anybody have anything they would like to say?
Mike?
No?
I've waited all day and I'm really tired. And I just can't believe that this can be postponed after all this time.
Are you here to speak in favor or against?
Against.
Okay. Thank you.
I received a letter a couple weeks ago.
About this
the-
hearing?
Yes, about the
Okay.
hearing. So if I did, he probably did too. So I can't see, I know it's late, everybody wants to go home. I do too, but I've been here since 8:45.
Yeah.
And the idea of coming back and having to wait another whole day, I'm not sure I'm up to it.
Okay.
Ma'am, can you state your name, please?
Gay Van Eer.
If we were to do a continuance,
I want to
Could
see
we
if there's
just-
more public comment.
Could you put him at the
understand.
top of the first one?
that's
I'm
what
gonna-
I'm wondering.
Oh,
ahead.
good idea. Okay. That was a good request, if we were to do that. We haven't made a decision yet, though.
If you did that, then I can live with that.
understand.
Okay, but not waiting another whole day,
I understand.
okay?
Is there any further public comment on this? No? Okay. The other issue that we would have is if the sheriff is going to be available if this were continued until
June 27th,
June 27th.
in the morning, first thing.
I'm available.
As long as there's no crisis.
Absolutely.
Got it.
Is there any reason we can't make it the first item on the agenda?
No, there's no reason we can't do that.
Okay, well, I could give you my opinion. When I see the public, and I've done this before, when I see them sit here all day and come here specifically for a hearing, and everybody's been noticed, I'm opposed to continuances in those scenarios. I don't think that when people get noticed, they should have to make arrangements to come back. I don't. But that's just my opinion. I think we should have the hearing. If he's not happy with the end result, he can appeal it to the supervisors. If he's happy, he goes away happy. But I don't think we should punish the public when we have properly noticed this in newspapers, via letters to neighbors and everything else. Plus, we have the sheriff setting his time aside for us.
I agree, and I think that there was an opportunity when the other cases came up and asked for a continuance. Nobody jumped up and said they'd like to continue theirs, so.
Okay, so I'm gonna poll everybody. Do you want a continuance? I don't.
I don't either.
I don't, but I vote for it. I think he has the right to.
Okay,
I think we should proceed with the hearing today.
okay.
Just on excess of caution and avoiding any claims of denial of representation, I'd be prepared to vote for the continuance, and with an immense apology to the members of the public that have been sitting through this all day. I just want to make sure that our record is clear and straight and with no questions.
Okay, so I have a 3-2 vote to carry on with the hearing today, taking note of both of your comments. So we will proceed with the hearing.
Very good. This is appeal number 2016-693. Ismael Silva is appealing a denial of commercial cannabis registration by the planning director. The registration was denied for the following reasons. The applicant did not produce evidence that no later than May 10th, 2016, cultivation, grading, or earth moving
commensurate with the area proposed to be developed had occurred on the site. Second, the application for registration contained false or misleading information. Third, the registrant was in violation of other local law. And the final reason was the sheriff has invalidated the registration based upon information discovered during a criminal background check. Site location is 2.5 acres at 8454 Cape City Road. That's in Mountain Ranch, Township 4 North, Range 13 East, Section 10. You can see here's Cape City Road, back into Michael Road, and on up Mountain Ranch Road into Mountain Ranch proper. And this is in District 2, obviously. On June 29, 2016, the applicant Ismael Silva filed a commercial cannabis cultivation registration for 5,200 square feet of mixed light cultivation area and was granted an application pending registration. The first cause for denial is it fails to meet the requirements of 1795-165N3 A and B. And that reads, the registrant must provide evidence satisfactory to the planning director that no later than May 10th, 2016, he or she has taken demonstrable steps toward the development of a commercial medical cannabis cultivation site on the parcel as demonstrated by the criteria described in either A or B below. A being date stamp photographic evidence of grading and or earth moving commensurate with the area proposed to be cultivated. B is date stamped photographic evidence of cultivation commensurate with the area proposed to be cultivated. The registrant submitted 5 photographs as evidence of its cultivation. None of the evidence photographs that were submitted showed any grading or earth moving, so we'll be looking at cultivation. The first 2 photographs you see up there on the screen, April 1st and April 20th of 2016, they show cannabis in a hoop house. You can see the hoop house back up here, and you can see it in the background in that photograph there. If we look at aerial imagery taken about that time, you'll see on the Terra Server aerial of May 1st, right here, there's no hoop house present on the side of the house. If we go to evidence on May 31st, Google aerial, you'll see there's a hoop house right there. So both of those photographs were dated in April. There was no hoop house present on May 1st, and there was a hoop house present on May 31st. So it's indeterminate as to when those photographs were actually taken. The third photograph is this April 15th photograph. It shows yellow field grass in the background. This is April 15th. The Terra Server aerial from May 1st shows green grass all around the site. So that photograph is also suspect. The final 2 cultivation photographs were actually the same photograph. I think these were included in the staff report, and actually, the physical photographs themselves, one is smaller, one is larger. And to put them both on the screen, I obviously adjusted it to make them both the same size, and when I did that, it just ended up being a real obvious replica. So it's a duplicate image, and in the image we see obviously two cannabis plants, and that certainly isn't equal to 5,200 square feet of cultivation area. It's not commensurate with that. So that is the basic reason why they were denied on those grounds. The photographs, the first 3, we could confirm by aerial photography that they were actually valid, and the final 2 were not. They didn't represent commensurate cultivation for the amount applied for. The second cause for denial was false and misleading information. That's County Code Section 1795-170A4, and that reads, registration of medical cannabis cultivation site pursuant to this chapter may be invalidated by the planning director for any of the following reasons. Number 4 is the application for registration contains false or misleading information. Again, the photograph of April 1st showing the hoop house, there was no hoop house on that site on May 1st, okay, a whole month later. the photograph from April 15th showing the, all of the dry yellow grass in the background. That's actually taken 2 weeks before the terrace river aerial of May 1st, which plainly shows green grass surrounding the cultivation site. So the photos don't depict the actual conditions on the ground, therefore the dates are suspect. And it was misleading because these photographs that were submitted purport to show cultivation that was underway prior to May 10th, when there was a deadline to have evidence and show that we were actually cultivating out on the parcel. The last, not the last, this is the third reason for denial, is compliance with state, federal, and local laws. And this has to do with County Code Section 1795 170A2, and that reads, registration of a medical cannabis cultivation site pursuant to this chapter may be invalidated by the planning director for any of the following reasons. Number 2 is other violations of federal, state, or local law other than cannabis-related activities recognized as legal by the state of California are occurring on the parcel within the county in the ownership or possession of the registration. This Google aerial of May 31st actually shows 4 greenhouses. It's very difficult to tell, but there are actually 4 greenhouses that were erected there. We didn't see it on the terrace river aerial of May 1st. They're not present. They were erected, though, by the time this was taken on May 31st. So there were 4 greenhouses put up without a permit. There is some code inspection history on this parcel. The code, code went out there on April 4th. They noticed that there was a shed under construction out on the site with no permits found in the building department. The registrant was advised to obtain permits on March 9th and March 10th. They were given verbal instruction that they needed to go down and obtain permits for both the greenhouses and the shed. There was actually nothing that happened on that. They didn't go down and submit any kind of application at the building department. So a stop work order was posted at the site on March 21st by code, and it required the registrant to submit and obtain those permits within 10 days. The registrant didn't follow up and take any action to meet that requirement. And therefore, because they because they failed to obtain permits for this work out on the site, the greenhouses and the sheds, they're found to be in violation of local laws and failed to meet the requirements of Section 1795 170A2. And the last reason for denial on this was invalidation of the registration by the sheriff, and based upon information discovered during the background check, the sheriff found cause to invalidate the application for registration, and that part of the presentation I would turn over to the sheriff.
Okay. With coffee.
Good evening.
Oh, wait, it is evening.
Evening.
I almost said good afternoon.
It's definitely evening. We sent a notice to the planning department. Find it. That was dated February 27th, that the applicant is currently a convicted felon. He's convicted of possessing a dangerous drug and was required to register as a narcotics offender. The conviction is deemed by our office to be invalidated.
Okay. We need to ask the appellant if he's willing to waive his rights before we can have any discussions on those items. So that we would need to know if it's okay with you if we can discuss any of that. Okay, so can you please come up to the mic? I need you to state your name, please, and can you write your name on that list, please?
Sure.
should I give him his 15 minutes now, do you think? I want to ask these questions? Okay. Okay, so I have some questions that I need to ask you so that we can have the sheriff be able to do his presentation, and then also you be able to rebuttal for yourself.
Excuse me, so what I'm going to recommend is that we just have the privacy issue dealt with right now. Let the sheriff complete his presentation after just the privacy issue is dealt with, and then that would be the conclusion of the presentation, then the appellant can begin his case.
Okay.
Yeah.
So do you want me to go through this, or just see if
Yeah.
he's going to, okay. So are you going to be appealing the denial of a registration based on your criminal history? Are you appealing that?
Yes.
Okay. Do you disagree that you were convicted of a crime?
Yes. I was convicted, but it was like 10 years ago, and I was on off probation, and it was supposed to be expunged. So.
Okay. Do you disagree that the conviction is reasonably related to the qualifications, functions, responsibilities, or duties expected of an applicant for the type of registration he or she is applying for?
You said, do I agree?
Yeah. Do you agree or disagree? Do you disagree that the conviction is related to the business license you've applied for?
Yeah.
You do, okay. Has the sheriff provided you with a copy of the criminal history information?
No.
Okay. Did you bring a copy of that?
I have the sheriff's office copy, yes.
Is he allowed to see that copy? Otherwise, we need to provide a copy to him as well.
I can show him a copy of it, absolutely.
Okay, good. In order for us to consider your side of the story, we would need to review the documents from the sheriff describing your criminal history. We are not allowed to review these documents without your permission. Do you give the Planning Commission permission to review your criminal history information, to discuss it during this hearing, and to place a copy of it into the record?
Yes.
Okay, and you realize we're publicly recording and on TV?
Yep.
Okay, perfect. Thank you. So now the sheriff can make his presentation.
According to the urgency ordinance, convicted felons are not supposed to be able to grow in our county. In March 24, 2008, he was arrested in Oakland for possession of methaqualone. I don't know, I'm not a druggist. It is a Schedule 1 or Schedule 2 drug it's only by prescription. He was convicted of that as a felony. So in the sheriff's eyes, that he is using illegal drugs, it's a felony. He's not supposed to be using them. So that is the reason that he was.
Is there anything in your records that that this is supposed to be expunged?
No,
You have nothing on there?
no.
Okay.
I wouldn't know that. If it was expunged or if it was reduced to a misdemeanor, he would have to petition the courts for that. It's a process. And if that's what he chooses to do, he has that ability. I believe it's under Prop 47. And according to this record, which is dated from the DOJ Wednesday, December 7th, 2016, he had not taken the steps to do that.
Okay, and what was the year of the conviction?
It was March 24th, 2008. He's correct, it was almost 10 years ago, but he's still classified as a convicted felon.
I apologize, do you want to go? Was that listed on his background record? Did he tell you that he had that on his history?
Let me look.
I know.
While the sheriff is looking, Paul has a copy of the notices he provided to the appellant, and now that he's waived his right to have us confidentially provide you with that copy.
Thank you. And you also give a copy to him so he knows what we have.
Absolutely, yeah.
Thank you.
And this was mailed to him already.
Okay. Yeah. Sheriff DiBasilio, I would also like for the appellant to be able to see a copy of the record that you have, but you said he was sent a copy of that?
Honestly, I do not know if our records division sends copies of these out. I don't know. I can't give you an honest answer. I don't know. But I am certainly glad to show him a copy of this now. And there is nothing in his background that shows that he had a conviction anyway in the paperwork that we have
Okay,
that
thank
he
you.
filled out. Sir, if you want to take a look at this. Oh, let me see what you have. See if that's the same.
I clearly wrote it on the background application. It happened.
Okay, well, there's, I asked that question because that's something that we've asked in previous hearings, but that's not part of the appeal. The appeal is the fact that it was a felony and the sheriff made a recommendation based on that in the urgency ordinance. So,
Sheriff, I have a quick
yeah,
question.
if it's,
Oh, I'm sorry.
I was just trying to see if it was reasonably related and if you had disclosed.
The letter that he has is what we sent to him, basically stating that he was denied because of this conviction.
Okay,
But the actual record, we do not send a copy of that record.
okay. So, and I'll let the other commissioners go forward with questions.
Do I understand correctly that if the conviction had been expunged, that would have been part of what you received, that information would be
That
part
would
of
have
what you
been,
received?
yes, that would have been put in the DOJ printout, that it would show that he was convicted, however, it would show that it was reduced to a misdemeanor, or expunged
Or
and taken
expunged.
out of the record altogether.
And if it had been expunged, would that change your recommendation as to this appeal?
Yes, he would not be a convicted felon at that point, so yes, it would.
All right, thank you.
Do any other commissioners have questions?
No.
Sir, did you want to see what this shows? This shows that it came from Department of Justice.
Yeah, my case was in San Leandro, so I'm confused why it's saying Oakland.
Well, you probably, because you got booked in Oakland, I don't know. But it shows that the court case was March 24, 2008. It shows the county, shows Oakland. So you're probably booked at the county jail.
I was looking in Santa Rita, like in the sheriff's.
That's county jail.
Yeah.
Right.
But it wasn't Oakland.
Well, Oakland is the one that probably arrested you.
No, it was sheriff's. But
Okay, well, I'm not going to argue with it. I'm just telling you what, this is all I know, is that it shows Oakland, and it shows the date, and it shows possession of methaqualone. I don't even know how to say that one.
Quaalude.
And then the original thing was for marijuana, but they dropped it.
The marijuana, correct, was dropped, 11/3/59.
Yeah, part of my deal, and they told me I can take the charge for the it was ecstasy. They told me I could take the charge for that, and they'll drop all the other cases, drop the rest of it, and that was part of my deal.
Okay, but that's what they did, but it's still a felony to have ecstasy.
Yeah.
And Sheriff, you see the relationship between that
Illegal drug activity.
illegal drug
Yes, sir.
activity and the current growth?
Yes, sir.
Thank you.
Okay. Is there any further questions of Sheriff DiBasilio?
No.
Okay, we'll hear from you. You can come up now. You will be able to give us a presentation on all the items that you're appealing today, which would be the photos, and also the sheriff, if you you can give us whatever you've got. Go ahead.
Like I said, I'm unprepared, and I really don't have anything to show right now.
Can you explain the photos?
The photos, I'm not sure why. We've been growing since we got there. They were just put up like on the porch, so I'm not sure. I could see why it didn't show up at first, but I'm not sure why the dates aren't adding up.
When did you get there? You said you've been
And
growing
we
since you
got those off a friend's phone that was helping us because we didn't have any pictures on our phone. So one of my friends that were helping me, he had took those pictures and we got them from him.
Okay, so you didn't submit these photos. A friend took them, printed them, gave them to you to submit with your application?
Yeah.
Okay.
And can you verify that the pictures within the hoop house were taken on April 20th?
Yeah, that's what it said on the date on his phone.
Well,
It said-
I'm asking you about your own personal
Yeah.
knowledge. Was there a hoop house on your property as
Yeah,
of
there
April
was a hoop
20th?
house.
And,
At first, we left the cover off for like, I'm not sure when we put the cover on, but the cover was off.
but the
For a
April
long time.
20th shows cover on the hoop house.
Yeah. See the other picture, it doesn't have it, and then that one it does.
Well, as I saw it, Paul, could you bring back, Paul,
Pardon?
could you bring back the hoop house pictures?
Yes,
The
I'm sorry.
pictures taken
There we go.
within the hoop house? That looks to me as if there's a cover on the hoop house in both the pictures as of April, the date given is April 20th. And yet, we don't see any hoop house on the premises as of May 1st.
I'm not sure.
When did you build the hoop house?
What happened?
When did you build the hoop house?
We built the hoop houses in, I guess, in the beginning of May.
Okay.
Did you have a different hoop house in April?
We just had like a portable one that we could just move. It was like a lightweight one we could just pick up and move.
And where was it located?
It was located like in the front of the house by the propane tank, and then on the side.
How big was it?
It was a 10 by 20. It was located over here in the front, and then over here by the propane tank.
Okay, the pictures that show the plants in some kind of a hoop house, were they taken in this little portable hoop house?
Yeah.
If we can go back to those pictures, Paul. I'm looking at the one on our right there. It looks as if, from my point of view, it looks as if that's at least a 15 to 20 foot distance between the foreground and the back of the background. So it looks like a large hoop house to me. It looks like
Yeah,
the
no,
hoop house.
that's 10 by 20. It's 10 feet wide and 20 feet long.
But you didn't have that as of April 20th, correct?
Yeah, we had it since we've been on the property.
Which
But-
was when?
But it doesn't show on the May 1st.
Yeah, I'm not sure why it's not showing up.
Okay.
Okay, so you were contacted by well, you weren't. You had somebody on the property that was contacted by code compliance. And they didn't allow code compliance to come on the property. And then you set up an appointment to meet with them and the corrections.
And
Can
we-
you talk
we
about
came
that?
And then we tried to get a permit, and they told us we had to figure out where our septic lines were at.
Okay,
So we figured that out, and then we found out that the septic tank, our septic lines were underneath our greenhouse, so we had to hire an engineer to come reroute our septic tank.
okay.
And we had to get that before our permit was issued.
So, when did you?
As soon as we got the letter, we tried, like, we went to go try to get the permits, and they told us that we couldn't, we had to get our septic tank rerouted before, and then we were just waiting on the engineers for that.
But you were already building the buildings, correct?
They were already built,
They were already built.
yeah.
When did you lease or rent this property?
In the beginning of this, in February,
In February of this year?
yeah, February,
2016?
Of 2016.
2016, yeah.
Okay, so they did go into the county 3 days later. And you guys were told on the 10th to stop construction on the shed, but it continued. A work order was posted on the 21st. By April 4th, which was a month later, they had not seen any building permits being pulled at the county or any permits.
We went in, but they wouldn't let us pull it, because we brought our planning. We brought our plans in, but they said it was gonna be not improved because of the septic. That was
Okay.
a problem, so we went and got, hired the engineers to come reroute them. and they were in the process of doing that now.
Okay, so we've got 3 issues we're dealing with. One is misleading photos because they're not making a whole lot of sense to us. You can't explain those, right?
Yes.
Okay. The second item is the code compliance issues that weren't corrected in a timely manner. And then the third item is the sheriff's report with the felony. And if you can help us out here and give us any information to explain any of those situations, otherwise we're being faced with a denial here. We've got 3 items against you in the report and in the denial that you received that we can't explain away. We need you to be able to explain these items to us. So if you've got any information that you could give us, or if your friend, person, no?
Yeah, 'cause like I said, with this background, I thought it was expunged, and that's what my lawyer had told me.
It sounds like you made a plea deal, not maybe expunging it, but you made a plea deal to remove all the other charges, but that one stayed.
Yeah, but it was after I got off probation, I was able to get it expunged. That's why I'm not sure, like, why.
Did you
popped
hire
up,
an
but
attorney?
Yes.
I'd follow up with that attorney. I don't know what else to say because it's not showing as expunged according to the sheriff, but I'm not a legal expert. Okay, do you have anything more you would like to add? If not, we'd like to get comment from the public.
Well, I have one question.
Great.
There's a photo dated April 15th. Could you put that up, Mr. Groh? The one on the left there.
Yeah.
It's dated April 15th, and yet there's dry grass in the background, which doesn't show up on the May 1 photo. Can you, do you know when that photo was actually taken? That's dated April 15th?
And like I said, I got the pictures from a friend that was working with me, but you can see it's like a little green on towards the end of the porch.
So you
I'm
didn't.
not sure why the images. I mean, the green grass is.
You didn't
shown
take
like
that photo, is that correct?
No, our friend, or one of our workers did.
And your friend put the date on it?
Yeah, it was printed like on the picture. It had the date on the iPhone.
How come it's not printed on this picture, sir?
Right here it says March 20th on it.
The date stamp for the photographs is posted above the photograph. It's not posted on the photograph.
Thank you.
Did you say that's showing the plants on a porch?
Yeah, it's on the porch on the side of the house.
That's not dirt.
Yeah, you can't see it from the
It's a deck,
from the
huh?
aerial view
Yeah.
because it
It's a
comes
deck.
out. Yeah.
Like a wooden deck or something?
Yeah. Like our roof
The
comes
grass
out
in the
like 10
background's
feet
dead.
around the whole house.
Some green though.
Is there a porch that goes around the whole house?
Yeah.
Yeah, correct. Yeah,
So
there's
that-
there's a long gable roof on this house, and it ends about 8 or 10 feet short on both sides, and then you can see where a porch or veranda goes around the whole side if we were to enlarge that.
And those plants, they're like probably like 3 weeks old, 3.5 weeks old.
So did you ever get the permits for the hoop houses?
No, we couldn't pull them because they were built over the septic tank.
So you're still out of compliance with code compliance?
Yeah.
Okay, okay. And you are the registered applicant?
Yes.
Okay. Okay.
Here's another picture of the stair with the green on, it's green grass, but our plants were still on the porch.
Is there a date on that?
Yeah. Is there any date? Yeah.
April what, I'm sorry? Thank you.
Okay.
Right here it shows it's green, but when we had this there, the plants were already they were on the porch, how they were.
Was that April 28, 2016 or 17?
It was 16.
Okay. Okay. Do you have anything further you'd like to add? Or any of the commissioners have any other questions?
Nothing else.
Okay. Then I'm going to go ahead and go to public comment now, and you'll get a chance to rebuttal. Thank you. Is there anybody here that has any public comment today?
Yeah, my name's Brad Veneer. I happen to be the neighbor to this. And besides the hoop houses and the shed, and they did some excavating without permits. They
Some what?
Excavating
Oh,
or
okay.
dirt work.
Thank
They
you.
did a cut and fill. They cut down some trees. They used the trees for a retaining wall, or they butt the fill up against it. It's just, I mean, I hate to say this, but Mr. Silva should have put his good foot forward and drawn permits for all the work that he's done. You know, I don't know, but that's all I have to say. I mean,
Thank you.
All of the grading work is done.
Okay, it's public comment right now. I gotta have you hold off until we're done. Thank you.
The grading was done without permits. I complained in writing, in person, on the phone, to everybody, Code Compliance, Planning Commission, Sheriff, even the Forester. Nothing was permitted, and they were told. And because they did move the greenhouses. The greenhouses were 35 feet from my property line. They moved one of the greenhouses back to 70 feet. The other one, they moved the plants, but left the greenhouse, and that's where they keep the fertilizer. I know they knew they were supposed to get permits. This was last year. I know because I've called a lot, and I've complained a lot. My house is about 40 feet from my property line, and I know that you're not supposed to be able to see a grow from the road, but these pictures show what I have to look at from my living room window, my bedroom window, my deck. And when they use the fertilizer, between the fertilizer and the marijuana, I cannot stay out on my deck because the smell is so horrific. As far as I'm concerned, everything they've done is illegal. They're still illegal. The only permit that's been pulled is for the new leach field. They never pulled permits for one thing because I've checked with more than one department. So I'm hoping you deny the appeal. And I appreciate you all staying. I know you want to go home. I want to go home too. But thank you very much.
Thank you. Is there any further public comment? No? Okay, then we're gonna close the public comments, and Paul, do you have any rebuttal?
No.
Would you like to come up now and you can rebuttal the public comments?
Yeah, like I said, like before we did all the grading and everything before the ordinance. And then ever since after the ordinance, we've been trying to get permits for everything that we need to get permits for. And then the only holdup was the septic tank people after we got everything drawn up.
Okay.
That's all we were waiting for.
Okay, well, thank you. We appreciate it. Unfortunately, and I'll just kind of start out, so we've got 3 issues on this denial, and 4, if you want it, okay. So I'm I'm going to uphold the denial by the planning department.
I agree with
I agree.
I don't see any other choice.
Okay.
I agree.
Okay, so can we get a recommendation read, please?
Yes. Staff recommends that the Planning Commission adopt Resolution 2017-041, denying Appeal 2016-693, thereby upholding the Planning Director's determination to deny application 2016-693.
Thank you. Can I get a motion? Second?
it. I'll second that.
Okay. All in favor, say aye.
Aye.
Aye. It's 5-0. Okay, Peter, would you like to read to him?
Sure. So this action denied your appeal. This action is appealable to the Board of Supervisors within 15 calendar days from today's date.
Did you understand what he's saying? Okay. So if you decide you want to fight any of this and you want to get representation, you can appeal it to the supervisors, but you have to do it in 15 days at the planning department. Okay. Thank you. Thank you for sticking with us all day. Well, Julie likes these nighttime shows. I'm a morning person, so she's coming up and I'm going down.
I don't like that. I'm just away.
Okay, so let's go on to, there is no study session, and if you say there is, okay, good. I'm gonna have an issue with that one. We do have on the agenda for a public comment period for anything not on the agenda. That is gonna be removed in the future. We discussed it 2 weeks ago, but inadvertently it got left on, so I do have to ask if anybody has anything they would say that is not on the agenda, now's your time to speak. Great. So now we will go to commissioner reports. Does anybody have anything they would like to report?
Not I.
Okay, I do. I would like to just kind of poll you guys that if Peter feels like the planning department is getting backlogged with hearings and he would like the opportunity to say, you guys, I want to hold a mid meeting like in the middle, instead of dragging it for 2 weeks and see if we can get some of that backlog caught up on these hearings, because we have to do them within a certain time frame and it would prevent these long nights. I would like to poll and make sure that you guys all say, hey, Peter, if you feel you need to do this, we're all with you. If not, we need to let him know now so he doesn't try and do that to us.
I'm good with it.
Go ahead.
I'm totally good with it, so.
Okay.
Can I abstain?
You always abstain. Okay, yes. You
Wait.
voted today.
This is my second. I didn't abstain.
I said you voted.
In principle, I'm in agreement, but if it's a time that I'm gonna be out of town or
Oh, we
whatever,
understand that. Peter would send an
you
email
know,
to the
so we'd have to
commissioners.
agree with.
And I guess sort of a corollary to that was, I was wondering if there are any scheduled vacations where we knew that you were not going to be here for a regularly scheduled meeting. We had a meeting the other day and it was probably not scheduled that way, but we only had 3 people. I wanted to make sure that if you knew you were going to be gone and going to miss a meeting, to let me know in advance. That way, if there were controversial issues, we could skip that meeting. So.
Why don't you just add my wife to your email list instead of me? And you find out whether I'm available. Because I don't know where I'm.
When I see you next week, I can give you,
Okay.
there's one
Yeah.
date for sure that I'm gonna be gone.
Yeah.
And you have to plan your vacations around the 2-week period of planning
I've
commission
done that
meetings.
all the rest of the year.
Thank you.
For my grandmother,
Thank you.
my
Okay.
granddaughter to see
All
Shakespeare
right,
in
so
San Diego.
do you have anything that you need to report out on?
Nothing else. That
Okay.
was it. Question.
So I am calling the meeting adjourned. Thank
Good.
you all for sticking in there today. Wait, Peter, wait for it. Is the camera off?